Hi everybody, welcome back to the 10th of an hour with Griffin Bridgers. For today's episode, episode 51, we're going to look at some hidden dangers in decanting trusts. A lot of these were listed in a recent New Hampshire Supreme Court case, Hodges versus Johnson, that we're going to dig into for a little bit as well. Now, as always, this presentation is not intended to substitute for legal or tax advice. Now, to start out, what is decanting in general? Well, really, a decanting is, in essence, an extension of the view of a trustee's discretionary distribution authority. So most trustees have the discretion to make distributions from a trust to beneficiaries, sometimes for some sort of standard like health, education, maintenance, and support. And sometimes there's no standard. That discretionary distribution is wide open, so the trustee could give all or nothing even at those extremes. But when you make distributions to a beneficiary, a lot of trusts also allow you to make distributions for the benefit of a beneficiary. This is kind of an indirect distribution. So decanting is really just a recognition of the trustee's power to make indirect distributions and stretching that into the thought that maybe instead of paying an expense directly, which is usually what's thought of as an indirect distribution, that maybe the trustee instead could put that property into a new trust for the beneficiary that might have different terms. So, like wine is decanted, the assets of a trust could be poured over into a new or modified trust if permitted under state law and under the terms of the trust. Really, this just extends the trustee's distribution power to allow distribution to a new trust for a beneficiary. But the problem is this can intersect in unknown ways or in unpredicted ways with the trustee's duties, especially when you get into things like decanting maybe to disinherit a beneficiary or reduce a beneficiary's interest in a trust. And that was illustrated in a recent New Hampshire Supreme Court case opinion in Hodges versus Johnson. In this case, the settlor created an irrevocable trust. It had a GST and non-GST exempt share, and the settlor's children and stepchildren were beneficiaries, and because of this blended family dynamic and the conflicts relating to the trust's primary asset, which was a family business, the settlor decided that he wished to disinherit a number of the trust beneficiaries, primarily the stepchildren and one of his own children in this case. So the settlor got an attorney who recommended that the trust be decanted, but because this was an irrevocable trust, somebody else was the trustee, not the settlor. The settlor named some of his business associates as trustees, and they went ahead and decanted to carry out this disinheritance. And then lo and behold, the disinherited beneficiaries sued, and the trial court ended up reversing the decanting. So this thing reached the Supreme Court level more on the question of whether the trustees could be reimbursed for their fees and time spent in erroneously decanting this trust and then subsequently trying to defend their own actions. Now, importantly in this case, the trial court found and every appellate court agreed that the trustees had substantially breached their duty of impartiality to the trust beneficiaries, not necessarily by the act of decanting itself, but because the outcome of this decanting didn't treat the beneficiaries equitably. So, because they took such a black and white view and viewed it as all or nothing in terms of disinheriting beneficiaries, really the court said that the trustees went too far and committed a substantial breach of the trust. So, there's a lot of things highlighted in this case opinion that really show the trustee risks here. One, who is driving the decanting? It's important to note that usually a decanting is encouraged maybe by a settlor or a beneficiary or somebody, but the trustees are the ones whose butts are on the line in terms of exercising their authority to make trust distributions, and in so doing, they have independent duties that have to be satisfied and taken into account. And they didn't do so here. They relied on settlor's instructions and the instructions of settlor's attorney. And then the trustees complained after the fact that they had to pay out of their own pocket for their defense costs, and even worse, that they had to pay the trust back for its defense costs. And the court looked at all these circumstances and said they didn't really go enough or do enough, first of all, to be able to support getting their costs reimbursed, because they could have petitioned the court for instructions, gotten independent counsel, but they didn't. They just kind of relied on the settlor's instructions and went about their merry way, forgetting that this was an irrevocable trust and that the settlor's power over that trust was non-existent. It held no weight, so they couldn't really be instruments of the settlor. And importantly, the trustees cited risk of litigation as to why they didn't take those steps up front, because they didn't want to stir up a hornet's nest in terms of the family dynamic. But the court didn't look at that as a sufficient excuse, because the end result was the same. The trustees essentially created a different conflict, and the trust assets could not be used to subsidize the defense of a conflict that the trustees had essentially created by decanting. So instead of avoiding a conflict, they created a new one. And finally, the trustees couldn't be indemnified for their bad actions and their breach of trust, because generally the court found that where there is a breach of trust, the trustees are on their own. They can't get reimbursed from the trust or be indemnified for their actions, especially when those actions rise under the UTC to being in bad faith or with reckless disregard for the terms of the trust. Now, the big takeaways here are, one, that the tax tail should not wag the family dynamics dog. Most decanting and irrevocable trust type of planning is tax-driven, but in this case, the settlor had regret after the fact for irrevocable tax planning that involved stepchildren and an ex-spouse, especially with a family business. So, before you really engage in a lot of tax planning, especially in a blended family, everybody should look at the dynamics and how they could change down the road and what exit options there are. Now, decanting is usually better than trust modification, be it judicial or non-judicial, because while the court can approve a modification of the trust, it has to involve all the parties, either by signature or notice. And decanting is more popular because it allows a more streamlined process to cut those parties out. But in doing so, it comes at the expense of trustee liability. Because importantly, from a tax perspective, when you can avoid a beneficiary's signature, you avoid potentially a gift tax liability if that beneficiary's interest is reduced. Now, a choice of trustee is key as well here, because you might want to have a trustee who knows enough to look at this and say, hey, here are my duties. Maybe I shouldn't be taking instructions. And I note on the last bullet point that the trustee should be careful not to be unduly influenced by the settlor or beneficiaries. And that kind of wraps into choice of trustee. You want somebody who can't be pushed around by the family and is willing to stand there, acknowledging their independent duties and not being pressured into making changes that are going to result in liability for them down the road. And then finally, decanting should ultimately be a collaborative process and not a surprise. And they wouldn't admit it here, but this is essentially what they're trying to do. They're trying to just surprise the disinherited beneficiaries and say, hey, we decanted this. Well, too bad, you're out of luck now. And the court still said, no, you can't really do that. Now, something like a non-judicial settlement agreement wrapper could have been effective here, because on the back end, the beneficiaries could have agreed maybe to give this a trustee that power, and that would have brought everybody to the table to have a good settlement, and then the benefited parties could have known the risks as well. So, decanting can be a great tool, but it can also be one that results in unknown trustee liability and expense, and court fights that go all the way to the state Supreme Court, as we're seeing in this case. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you for listening to this episode of The 10th of an Hour, and I look forward to seeing you in the next one.